In this video, we're going to talk about the Texas contract, the third-party finance addendum, and the seller's disclosure. Once again, please note that this video does not constitute legal advice. That can only come from a licensed attorney in the state of Texas. This is just to go over some of the common questions that come up and explain a few parts of it. So in the first part of our contract, very obviously we have who the parties are, who the seller and who the buyer is. Next, we talk about the property itself. This is called the legal description, the lot, block, and section, and also the address. A question that also comes up is what comes with the home. So in Texas, anything that is permanently attached to the home is assumed that it comes with it. There are a couple exceptions to that, mainly being TV brackets. The TV does not come with it. The bracket, if it's affixed to the wall, does. So again, if there's any questions about different things like speakers, mirrors, stuff like that, it's best to get it in writing exactly what comes and what doesn't come with it. One of the things you can also do is here under exclusions, they can list things. So for example, speakers that are screwed into the wall would be assumed that they come with it. However, a seller can put on here on exclusions that it does not come with those speakers. So again, very, very key into understanding what comes with it and what doesn't. And please remember, it's what's on the contract that matters. So please make sure anything that's been indicated on, let's say, a website or anything else makes it to the contract. The next part is the sales price, and this is divided up by the cash portion. This is also known as the down payment right here. And the second thing is the sum of all financing, or how much that you're going to borrow. And the reason it's important to get this correct is because this is what you're telling the seller you're going to be applying for financing. So sometimes sellers will give preference to offers that you're putting more down, like let's say 20% versus less. Plus, this is also going to tie with the next document, the third-party financing. So it's vital to make sure that you get this right. Any deviances from this don't automatically mean a breach of contract, but this is what you are hinging the contract on. So for example, if you say you're putting 20% down, you only put 10% down and you're approved, that's okay. The real problem is when you say that you're approved for 20% down and you're not, and then you've got to go up or down and the contract falls apart, because again, this is what it's based off of. So the next thing we're going to talk about is on here, third-party financing. This is again considered your loan amount. And the thing under here we need to pay attention to is property approval. If the property does not satisfy the lender's underwriting requirements for loan, including but not limited to appraisal, insurability, and lender required repairs, buyer may terminate the contract and receive their earnest money back. So again, this is real important. This is where our appraisal comes in, insurability, and also lender required repairs. Although the lender does not go out and inspect the property, certain property conditions can appear in an appraisal. For example, if the appraiser goes out there and notes that there is a huge 2-inch crack on an exterior wall, that could become a lender required repair. So moving down, this is very important to make sure if you're financing that you check this box that the contract is subject to the buyer being financed. If for some reason you want to waive that, you can go ahead and check this box right here, but we very, very rarely see that. Next are assumptions in seller financing, which we don't really see a whole lot of. So the next is going to be earnest money, which is money that you're going to put up that, assuming the transaction closed, does go towards your total closing costs, or the total amount that you have to bring to it. And this paragraph just states how much you're going to put down, who you're going to put it down with, and their address. Next is title policy. We'll have a separate video later on in the series explaining what that is, but this establishes who's going to pay for it. In Texas, most of the time with resales, we see the seller paying for it. When it comes to new builds, sometimes it can be 50-50. But again, it's important that we know exactly who's paying for it. So next we go down to the title commitment, which is issued by the title company. And on here we have different things about the commitment. Also we have a survey, and this just states if there's an existing survey, how long the seller has to provide it. And also if for some reason the buyer's lender or the title company won't accept it, who's going to pay for the new survey. And then also you can waive it and just require a new survey altogether at buyer or seller's expense. Next is objections. So let's say the title commitment comes out and for some reason they prohibit a single family home being built on the property or being lived in. This is where you would list those exceptions, and could be an out on the contract as well. And again, give it a time frame. Next, membership in Property Owners Association. That's a long fancy word for homeowners association, and this just signifies whether the property is or isn't part of one. Next is property condition. So the important thing to remember is that in the contract it states seller shall permit buyer and buyer's agents access to the property at reasonable times. This is for inspections, and unless otherwise noted, seller at seller's expense shall immediately cause existing utilities to be turned on and shall keep utilities on during the time this contract is in effect. So again, one thing to make sure is turned on, especially if the home was previously a rental or maybe a foreclosure or something like that. It's just about impossible for an inspector to do a proper inspection on a home with no electricity, water, or gas, or one or the other. Next thing is the seller's disclosure. This just states either whether you've received it, you haven't received it, and how many days they have to get it to you, or if the seller is not required to furnish it. And normally we see no seller's disclosure when it comes to foreclosures and estate properties. Next thing, we talk about acceptance of property condition. So we have two choices on here: that the buyer accepts the property as is, or accepts the property as is, provided the seller at seller's expense complete the following repairs. Most of the time we see just the property as is box checked, because most contracts will contain the unrestricted right to terminate, which is also known as the option period, where you go and have it inspected. But sometimes we'll go in and we'll look at a house and we'll see a really big item that absolutely has to be repaired. Let's say it's foundation work or maybe a new roof, and the buyer doesn't want to pay for an inspection, only to come to find out later that the seller won't do that. So what they could do is easily, in this case, just check box number 2 and put seller to replace shingles or whatever that repair is. So at least you know they've agreed on that. You still have the right to inspect it and go back and negotiate additional repairs, but this just puts something on paper that you know up front. Lender required repairs. Again, we've talked a little bit about that. If these come up in the appraisal report or any other way. Completion of repairs. It's important to know that sellers shall complete agreed repairs and treatments prior to closing date. Also, all required permits must be obtained, and repairs and treatments must be performed by persons who are licensed to provide such repairs or treatments, or if no license is required by law, are commercially engaged in the trade of providing such repairs or treatments. So basically what this is saying is, if there's a license for the repair, unless it's otherwise agreed upon, it has to be done by a licensed person, meaning if there's an AC problem, it can't be a handyman that fixes it. It has to be a licensed air conditioning technician. But for example, let's say fencing. There's no license requirements for fencing, but you can't have a plumber go fix a fence. You have to have a fence company, even though they're not licensed. Next is residential service contracts, and these are often referred to as home warranties. I do want to caution you, though, in calling it a warranty, as there's a little bit difference between this type of warranty and what you'll normally have on, let's say, a car or an appliance. Please look at these as cost reduction services, because there are deductibles, there are limits of coverage, and pre-existing conditions. So again, don't look at these as like a car warranty where something breaks, they fix it for free. Look at it as a cost reduction service. Next, we go into closing date. That's pretty self-explanatory. Possession. Please keep in mind that you do not actually possess the home until the loan is closed and funded. So a lot of people think that, well, we sign the papers, we get the keys. Well, not exactly. There's a process called funding, where the title company will send the forms to the lender to release the money. That's called funding, and once it's funded, you get your keys. Special provisions. This is where we can write things applying to the contract. It's usually very discouraged to do something like that, as all verbiage in there can constitute a legally binding agreement, and that's usually done by lawyers, not realtors, buyers, and sellers. Next thing on here is sellers shall also pay an amount not to exceed, and there's a blank to be filled in. This is where the closing cost contribution would be. Please keep in mind there's really no tricking people. If there's a large number in there, they'll probably go back to the first page and see the price, subtract the two, and that's essentially what your offer price is. So at times when funds might be short, maybe you're buying your first home, it's perfectly acceptable to ask for it, but don't just put it in there if you don't need the money, because they will see it and consider it a lower offer price if they have to pay a large number in closing costs. Next, we talk about default. This just states what happens if the buyer fails to comply with the contract. Seller may do what's called specific performance, which is make you close, or terminate the contract and receive your earnest money as liquidated damages. So definitely one thing to keep in mind, that there is a default clause in here. It's not always just about, well, I'll cancel the contract and lose my earnest money. We don't see a whole lot of specific performance or people being made to close, but just know that it is there. This next section is just going to check what addendum applied to the contract. Next is our termination option, also known as the unrestricted right to terminate. So this is also known as the option fee. So once you pay this fee in the set amount of days, in this case we have, just for example, 10 days, within that 10-day period, for whatever reason you want, you can cancel the contract, get your earnest money back, and the only thing you would give up would be your, in this case, $100 for your option fee. Now please keep in mind that $100 does go towards closing if you do proceed with the contract, and down below you have this option fee will be credited to the sales price. So again, this is a very safe way of being able to put a property under contract. And again, for just your $100 fee, and maybe if you've already had it inspected, whatever inspection costs you have, gives you an out if for some reason you decide the home is not for you. Or also it's a great out if you can't agree on repairs with the seller. So again, that's our termination option. Option fee, also known as unrestricted right to terminate. Here's where the contract is signed, and the next page is just agent information. So on here, we're now going to go over the third-party financing addendum, which we talked about on the first page of the contract. And this just basically says that you're going to apply for the financing you stated, and if you can't get credit approval within 21 days, in this case, that's what we filled in this contract, you can give notice and you'll get your earnest money back. But please keep in mind, for example, if for some reason, let's say in this case, on day 22, your lender calls you and says, sorry, we can't approve you, and it's not based on the appraisal or lender required repairs or insurability, you are at breach of contract and you can lose your earnest money. So it's very important that we watch this date and make sure that our lenders are performing and we're getting everything to them possible that they ask for. And so down here, we're just going to say this is a conventional loan. This just states that by checking the box, what your loan amount is. It's a 30-year loan, your interest rate for the 30 years, and fees or origination charges, what percentage they can be. And so essentially, if within these 21 days you can't obtain this financing, your earnest money will be refunded to you. Now keep in mind, it's not automatic. There is a form in Texas that both parties have to sign to release the earnest money. And if you're not doing a conventional loan, let's say it's a veterans loan, FHA, VA, or USDA, here's where all that will be entered. So next we're going to talk about another form you'll see a lot, and that's the seller's disclosure. Keep in mind, it's a property owner's job to let you know things that they know about. So for example, if they know that their heater doesn't work, they have to tell you. If they don't know that a closet light is burnt out or for some reason doesn't work and it's not their knowledge, they don't have to. So it's only things that they know about. So in here we talk about obviously the address, and it states whether or not they're occupying the property. So this first section is going to have just the property has the items marked below, and they just mark yes, no, or unknown. Down here as well, and here they're going to mark whether it's, let's say, central heat, whether it's electric, gas, number of units, also garage door openers, a whole lot of different things about the home itself. We're also going to talk about how the water is supplied. A key thing in homes is, was it built before 1978? If it was, you'll need an addendum regarding lead-based paint hazards. We'll also talk about the roof type and age, and is there an overlay? And then also a thing over here, are you aware of any other items listed in Section 1 that are not in working condition, have defects, or in need of repair? So this just gives them maybe something needs repair, it doesn't really fit on that list, here's where it would go. Next, we talk about defects and malfunctions also. So they're going to check yes or no whether there's defects or malfunctions in any of these areas. and then here they'll be able to explain. And please only settle for a detailed explanation. So something like home previously flooded is not acceptable. You need to know exactly what happened, what the repairs were, and as much detailed information as you can. So next we're going to talk about, are you aware of the following conditions? And again, it goes down here as well. And also it gives them a section to kind of write in. Also, if it doesn't fit in those two sections, they can put it here in section 4. And then there's a few questions they're going to ask. Were there any room additions, structural modifications, or other alterations or repairs made without necessary permits or not in compliance with building codes? So we see this a lot when it comes to, let's say, sheds that might not be approved by a homeowners association, patios that are closed in, things like that. So we need to make sure if there are these improvements that we know whether or not they were made with or without the necessary permits or in compliance with building codes. Next, this talks about the homeowners association and how much the fees are. Any common areas co-owned. Next, are there any notices of violation of deed restrictions? Any lawsuits or other legal proceedings affecting it? And this is a key one also. Any death on the property except for those deaths caused by natural causes, suicide, or accident unrelated to the condition of the property. So, for example, if someone died of an illness in the home, that doesn't have to be disclosed. If a crime happened and someone died, that does have to be disclosed. Accident unrelated to the property, I like to kind of say it like this. Let's say if, heaven forbid, somebody hangs himself from a wood beam inside the home. That's considered suicide, doesn't have to be disclosed. Let's say someone's sitting on the couch and that same wood beam cracks and knocks them in the head and they die. That would be a condition of the property that does have to be disclosed. So please keep in mind this is no big deal, but there is another seller's disclosure that's commonly used that doesn't ask this question at all. So if you see that other seller's disclosure, not this one we're going over, that might be kind of a red flag that something like that might have happened in that home. It's just very rare that we see those. Next is any condition of the property which materially affects the health or safety of an individual. Any repairs or treatments other than routine maintenance made to the property to remediate environmental hazards, and it lists them. Rainwater harvesting system, and is the property located in a propane gas system service area? Next, if you answered yes, it's got a little place to go into detail. Whether or not they've attached a survey, and within the last 4 years, has the seller received any written inspection reports from persons who regularly provide inspections and who are either licensed as inspectors or otherwise permitted by law. So if you do see something on here, it might not be a bad idea to ask for a copy of it and just find out what it was. Maybe it's the home was under contract before and they have a previous inspection report, or maybe if they've only been in the home a year or two and have their original reports, it might be good to kind of look through so the inspector can kind of compare what was the condition of the property a year or two ago or whenever it was done versus now. Next, is very important that they check any tax exemptions, which they have, because some of those might or might not carry over. It asks if you've ever filed a claim for damage to the property with any insurance provider, and if you've received proceeds for the claim, did you not make the repairs? Very important to know. And lastly, it asks a question about smoke detectors. Please keep in mind that this is about smoke detectors and not carbon monoxide detectors. Huge difference, and I encourage everybody to get carbon monoxide detectors installed in their home. Smoke detectors themselves are not enough. Then finally, our signature notices and utility providers, etc. So again, that's just a basic overview of 3 of the documents you'll see in a contract. Again, this is not legal advice, just to answer questions that come up as far as what they are. Please keep in mind there will be a whole lot more addendum and forms that you'll need to sign, and you'll definitely want to read over those as well.